Thank you, Congresswoman Waters, Congressman Conyers, members of the committee. Thank you for your leadership. Thank you for hosting this forum today. My name is John Bonifaz. I am a Boston-based attorney specializing in constitutional litigation and the co-founder of AfterDowningstreet.org. While it is also true, as Congressman Conyers referenced in the opening, that I serve as General Counsel for the National Voting Rights Institute, I am here in my private capacity as a constitutional attorney in Boston and as the co-founder of AfterDowningstreet.org. AfterDowningstreet.org is a national coalition of veterans groups, peace groups, public interest organizations, and ordinary citizens across this country calling for a formal congressional investigation into whether the President of the United States has committed impeachable offenses in connection with the Iraq War. We launched this campaign on May 26th of this year in response to the revelations which have emerged from the release of the Downing Street Minutes. The recent release of the Downing Street Minutes provides new and compelling evidence that the President of the United States has been actively engaged in a conspiracy to deceive and mislead the United States Congress and the American people about the basis for going to war against Iraq. If true, such conduct constitutes a high crime under Article 2, Section 4 of the United States Constitution, which states, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." As has previously been stated, the Downing Street Minutes reveal that by the summer of 2002, President Bush had decided to overthrow Iraqi President Saddam Hussein by launching a war which Richard Dearlove, the senior British intelligence officer, reports would be, quote, justified by the conjunction of terrorism and WMD, weapons of mass destruction. Dearlove continues, but the intelligence and facts were being fixed around the policy. The framers of the United States Constitution drafted Article 2, Section 4 to ensure that the people of the United States, through their representatives in the United States Congress, could hold a president accountable for an abuse of power and an abuse of the public trust. James Madison, speaking at Virginia's ratifying convention, stated, "A president is impeachable if he attempts to subvert the Constitution." Alexander Hamilton, writing in the Federalist, stated that the impeachment is for the misconduct of public men from the abuse or violation of some public trust. James Iredell, who later became a justice of the United States Supreme Court, stated at North Carolina's ratifying convention, "The President must certainly be punishable for giving false information to the Senate. He is to regulate all intercourse with foreign powers, and it is his duty to impart to the Senate every material intelligence he receives." Iredell went on to say that if the President, quote, has concealed important intelligence which he ought to have communicated, and by that means induced the Congress to enter into measures injurious to their country, and which they would not have consented to had the true state of things been disclosed to them, end quote, then he says that ought to be considered an impeachable offense. On July 25, 1974, then Representative Barbara Jordan spoke to her colleagues on the House Judiciary Committee of the constitutional basis for impeachment. "The powers relating to impeachment," Jordan said, "are an essential check in the hands of this body, the legislature, against and upon the encroachment of the executive. Impeachment," she added, "is chiefly designed for the President and his high ministers to somehow be called into account. It is designed to bridle the executive if he engages in excesses. It is designed as a method of national inquest into the conduct of public men. The framers confined in the Congress the power," Representative Barbara Jordan said, "if need be, to remove the President in order to strike a delicate balance between a President swollen with power and grown tyrannical and preservation of the independence of the executive. The question must now be asked, with the release of the Downing Street minutes, whether the President has committed impeachable offenses. Is it a high crime to engage in a conspiracy to deceive and mislead the United States Congress and the American people about the basis for taking the nation into war? Is it a high crime to manipulate intelligence so as to allege falsely a national security threat posed to the United States as a means of trying to justify a war against another nation based on preemptive purposes? Is it a high crime to commit a felony via the submission of an official report to the United States Congress falsifying the reasons for launching military action? Congressman Conyers, members of the committee, the Downing Street minutes shed new and important light on a document the President himself submitted to the United States Congress within 48 hours after having launched the invasion of Iraq. This is the document, and I have distributed it to all of you, and I've asked that it be put into the record of these proceedings.
Without objection, so ordered.
In the letter, dated March 18, 2003, the President makes a formal determination, as required by the joint resolution on Iraq passed by the United States Congress in October 2002, that military action against Iraq was necessary to, quote, protect the national security of the United States against the continuing threat posed by Iraq. He also states in this letter to Congress that military action was consistent with the United States and other countries continuing to take the necessary actions against international terrorists and terrorist organizations, including those nations, organizations, or persons who planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001. If the evidence revealed by the Downing Street minutes is true, then the President's submission of his March 18, 2003 letter to the United States Congress would violate federal criminal law, including the federal anti-conspiracy statute, which makes it a felony, quote, to commit any offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose. And the False Statements Accountability Act of 1996, which makes it a felony to issue knowingly and willfully false statements to the United States Congress. The United States House of Representatives has a constitutional duty to investigate fully and comprehensively the evidence revealed by the Downing Street minutes and other related evidence, and to determine whether there are sufficient grounds to impeach George W. Bush, the President of the United States. A resolution of inquiry is the appropriate first step in launching this investigation. The Iraq War has led to the death of more than 1,700 United States soldiers and tens of thousands of Iraqi civilians. Thousands more have been permanently and severely injured on both sides. More than 2 years after the invasion, Iraq remains unstable and its future unclear. The war has already cost the American people tens of billions of taxpayer dollars at the expense of basic human needs here at home. More than 135,000 United States soldiers remain in Iraq without any stated exit plan. If the President has committed high crimes in connection with this war, he must be held accountable. The United States Constitution demands no less. Thank you.